So it's 12 o'clock. We'll go ahead and get started. Thank you again, everybody, for joining us today for the Supreme Court Review CLE. As a reminder, today's session is an hour and a half program, so we will go until 1:30. The session is being recorded, so please do keep your microphones muted and your cameras off if you are not one of our presenters. If you have questions during the session, please enter them in the chat. We will have time for questions at the end, and we'll make sure that those get relayed to our presenters. As I mentioned, I will put the CLE credit information in the chat. So you have the credit number. We have had this approved for 1.5 standard CLE credits. And with that, there's a lot of information to cover, so I would like to turn it over to our speakers now. Our speakers today are Professor David Schultz and Marshall Tanick, and I will turn it over to you.
Great. Thank you very much, and Happy New Year to everybody. And my name is David Schultz, and I'm both a professor of political science at Hamline University in St. Paul, Minnesota. And I used to be at the U in the law school, but moved over to the University of St. Thomas. And so I live in two different worlds, both the world of law and the world of political science. And that's going to be important in terms of us, at least part of my presentation today. So what we're going to try to do today between me, Marshall, or Marshall and me, I should say, is give you both an overview of what happened in an amazing term from last year, and then especially with Marshall, with some type of projections in terms of where we're going to head. So what I'm going to do is start with my presentation first, and I'll share my screen in a second here and get it up and running in a second. I'm going to talk for about 25 minutes or so and kind of do an overview of some what I call sort of maybe the baseball statistics, a lot of really interesting information, at least I think, regarding the Supreme Court and the term that just ended. I'll stop, turn it over to Marshall, who's going to talk for a while, kind of shoot it back to me. I'll talk a few more topics back to him and leave plenty of time for questions and answers. But also, right before we went on, I mentioned to Sarah that if some of you do want to pose some questions regarding my part of the presentation on the first part there, please feel free to put those in. And what I will do is before I turn it over to Marshall in about, like I said, 25 or 30 minutes, I'm more than happy to entertain some of your questions, because I don't really need to have you folks sort of waiting with bated breath for like, 80 minutes or something like that. I'm posing a question. So let me just get to my screen. I think this is the one I want. And just to be sure, we should be up and running. Sarah, everybody can see it, I hope? Good.
Yes, we can see it.
All right, excellent. Just wanted to be sure. Okay, so review of the 2023 term. Actually, I still have it listed as Minnesota School of Law. I should have probably changed that, but I will. Okay, so I always like to start off with, again, major highlights. And by the way, pardon me a little bit today if I'm a little congested, just a little bit of a head cold, perhaps. So pardon me on that. So some observations and highlights from the 23-24 Supreme Court term. And 6-3 is all you need to know. Justice William Brennan was famous many, many, many years ago when he was on the court. On the very first day when he was introducing his clerks or meeting his new law clerks, supposedly he would say to them, he would hold up his hand with 5 and say, 5 is all you need to know. That if you have 5 votes, you can do whatever you want on the Supreme Court. Well, we're going to talk about how the court is basically divided 6-3. And with a 6-3 divide, that clearly tells you a lot regarding what the court can do and who is in charge. Okay. Second, we'll point out how Donald Trump's court, and I say Donald Trump's court because 3 of those justices were appointed by him, deliver big wins for Donald Trump, both Donald Trump in terms of as individual and perhaps as president of the United States. Administrative agencies lose. Right before we came on the air, Marshall, Sarah, and I were talking about the fact that I think I have to attend Administrative Law Anonymous, because I've been an administrative law geek for now, 25 years or so, and very much interested in it. And I want to talk a little bit about how this term, in a variety of ways, administrative agencies lost on some big cases. Second Amendment mostly wins. The homeless lose. For now, at least, emergency abortions and birth control are safe for now. Also with that, a I'm going to call it a slow court. I don't mean in terms of miles per hour, but in terms of a court that does not seem to be moving very quickly and turning cases around very quickly. And I'll talk more about that. A court with a low workload seems to be taking its time to render opinions. Um, Less unanimity, more concurrences, and then gifts, trips, and conflicts, controversies. So a whole bunch of, I think, interesting things that to report in terms of the of where the court was, and of course setting the stage for where, and Marshall will talk about it, and I will too, in terms of where the court is headed this term and perhaps even further down the line here. So I mentioned to you in my introduction that I'm both a political scientist and both a law professor at the same time. And the reason why I mention that is that think back to the time when you were in law school and had to face really gnarly professors like me, who we would pose to you a couple of cases, and then we would say to you, especially Supreme Court cases, we would ask you, how do you reconcile these? And we would torch you in all kinds of ways to figuring out how the court had shaved the precedent or what the legal principle was, some way of figuring out how we could somehow reconcile these opinions. And I know many of you probably wanted to just raise your hand at some point and say, the reason why we have two different decisions is because guess what? The power dynamics on the court came out differently, or different appointments or something. And that's not supposed to be the answer in law school. But we want to think about this today a little bit in terms of two models. One I call the judicial model, and this is the model that basically says that when the court acts as an apolitical institution, and it renders decisions apolitically, versus the political science model, which really looks at the court as being a political institution, the justices as political actors and acting appropriately or accordingly. So I'm going to actually spend a little more time on that here. And so when we start to think about these two different models here, on the judicial model, which is really a model that goes back to Alexander Hamilton, goes back to Federalist number 78, and it's the argument that says that the way the court structure is set up for the Supreme Court, the nomination and confirmation process, the way that the justices have tenure for life subject to good behavior is all the court supposed to, according to Alexander Hamilton, to take the court out of politics. I was pointing out to my students, this past semester, is think back to 1787, the situation where the president was selected by the electoral college, no popular vote. The Senate was selected by state legislatures, not popular vote. You could almost sort of see Hamilton's argument that the president above politics, the Senate above politics, they pick Supreme Court justices, president subject to Senate confirmation, somehow above politics. Could almost see that. But that's sort of our myth, the myth that the court is above politics, that it renders just judgments, it makes decisions based upon legal principles, the text, upon precedent, and it does not engage in any type of political controversies. And therefore, the law school model that we all were subjected to is a model that says, let's discount, let's ignore the political dynamics or political factors influencing how the court renders its opinions, and instead focus on, again, as I just mentioned here, the doctrines or principles that drive their decisions. And that's an important model. That may be an important story or belief that we want to have. I think we don't want to believe that the political composition of the judiciary, who the justices, what their political biases may be, is going to render opinions. We sort of want to hope, as we have here, that justice is blind, and that if we were to look at the outside of the Supreme Court building, which says equal justice for all, or equal justice under law, that we all have a fair shot of going before the court and having our case heard. But there's also the political science model. As I mentioned, the political science model that says that the court is a political institution, much in the same way that Congress, the presidency is, that the justices are political actors. Maybe we go so far as to say they are politicians wearing robes, that the justices have their own political biases, they have their political agendas, they compete with one another and for political influence, and the court itself competes for influence in making public policy with the other two branches of government. And the reason why I sketch out these two models here is that I want us to think about those two models as we move forward in my presentation today. Perhaps which one offers a better explanation regarding how the Supreme Court rendered many of its opinions? Do we see, for example, that the court is surprising us? For example, where justices are issuing opinions that we might not expect because they're acting, apolitically, or do we look at it and say, well, yeah, I kind of expected Thomas or Sotomayor to decide this case the way she did? So I just throw this out here, and I wanted to bring this out for the last couple of years in my presentations, just so we become aware and think about perhaps how we think about how justices and judges decide cases. So,
Professor Schultz, before you go on, can I ask you to put that into screen share mode so that we are into the slideshow
oh, you
mode so
are.
it can be a little bit bigger?
Oh, okay. Let me do that. Okay, I'll do that. Hold on a second.
I think
It
if you
should
just
be.
click that little button there, it
There
should.
it is.
Okay,
Is that better?
it is. Thank you.
I knew I forgot something. Thank you for telling me. Okay. So having said that, I updated this as of yesterday. Some interesting information that looks at the composition of the federal courts in terms of uh, who's appointed in terms of Democratic appointments or Republican appointments. And I think I mostly have my numbers right, although I'm looking at it here and I think I'm a little off now in some of my updates here, but this is roughly correct at this point. Right now, there are 678 federal district court judges, 377 appointed by Democratic presidents, 264 by Republicans. This is where my math might be off a little bit. 8 circuits are a majority with Democrats, 4 circuits are a majority with Republicans. As of yesterday, there still appeared to be about 40 district court vacancies. I know the Democrats were trying to, as hard and as vigorously as possible, to try to fill all the vacancies. But obviously, as you fill vacancies, new vacancies occur. But that kind of gives you one picture. At the Court of Appeals, there are 179 Court of Appeals judges, 87 appointed by Democrats, 90 appointed by Republican presidents, 7 circuits with a majority Democrat, 6 circuits with a majority Republican, 2 appeals court vacancies. And just for some trivia here, in the closing days of the last Congress, Joe Biden surpassed Donald Trump in terms of the total number of judges appointed to the federal bench. Biden 235, Trump 234. But obviously, with Trump taking over the presidency, he will surpass that. But if we're looking at it here right now, there is a slight tipping in favor of judges appointed by Democrats. And there's been some stories in the news, which I didn't work into the PowerPoint, where after the election, some judges were rethinking whether they were going to step down or stay on the bench, depending on the fact that Trump got elected. And just for a little bit more trivia here, the president that has appointed the most federal judges ever isn't Roosevelt, it's Ronald Reagan. And in honor of Jimmy Carter, the president who's appointed the most judges in any one term is Jimmy Carter, although he also holds the distinction of never having appointed a Supreme Court justice. And I think he holds that honor with William Henry Harrison, who served in the presidency for only 30 days and appointed no judges to the federal bench. And so you've gotten your full stock of all types of trivia at this point. Okay, now, elections matter or not. Both the legal and political science models clearly have some cogency, that we can look at lots of data out there and say that, yeah, here are a lot of cases where the judges and justices, especially for our cases, the justices do not appear to be operating from any type of sort of, political biases. They're deciding cases, whether it's on the First Amendment, free speech, or equal protection, based upon what looks like the law. But it also does look like, in many cases, that elections do matter, that we have clear patterns, especially in the last 25 years or so, that the appointing president or identifying which president appointed a justice becomes a pretty good determinant of telling us how that justice is going to vote. And it really raises the question, is or should the Supreme Court be above public opinion? Or maybe a better way of phrasing it here, is it even possible? Is it at the end of the day, do we want the court to be following public opinion? And in some cases, I think we would say yes. I think for those who are critical of the Dobbs decision in overturning abortion, Roe versus Wade, many would say the court should have followed opinion. But for many who say the court should defend free speech rights, regardless of how unpopular, the argument would be no, it should not. So I just sort of throw this out here. And again, in light of the fact that we just had a presidential election and we're going to see perhaps who knows how many scores of new judges go on the bench and perhaps several new Supreme Court justices, let's keep this in mind here. Okay, so now, nice work if you can get it, comparing the 2022 and the 2021 docket. Actually, supposed to say, supposed to be a typo here. I guess it here. The 2022 term, 2023 term. My apologies here. Is that we saw in 2022 an agreement to hear 60 cases, 58 merit opinions released, one dismissal. In the 2023 term, the one that just ended, they agreed to hear 62 cases, two cases dismissed, 60 merit opinions issued. I just bring this up because if Marshall and I, back when we were children, infants, if we were doing this CLE back in the 70s, for example, we would point out how the Supreme Court was rendering way in excess of 200 merit opinions every term. And the fact is now it's issuing significantly less. And especially under the Roberts Court, we could see a significant downturn in the number of cases, number of opinions issued. And there could be all kinds of reasons for that. But I just want to sort of note it here in terms of looking at it here. And put it in contrast here, approximately 8,000 cert petitions to the U.S. Supreme Court each year in recent history, which means with only 60 or so being accepted per year, the odds of you getting up to the Supreme Court are pretty low at this point in terms of a case being accepted. But again, just interesting statistics to look at here. Case origin. And I told Sarah that she could share my PowerPoint with everybody. And even though I've enlarged my screen here, and it might be marginally easier to look at, it's still probably a little bit difficult to look at here. And what I did is to put together a list of the court of origin from where a case was granted cert, goes up to the Supreme Court, and then what the court did with it and so forth. And so, for example, if I were looking at the First Circuit, the Supreme Court took two cases from the First Circuit and it reversed both of those cases, and therefore percent reversed. And so I sort of put this together here. And if you look at it, the first, the fourth, sixth, and seventh, and the federal circuit and the state courts were reversed 100% of the time. Odds are that if the Supreme Court takes your case, it looks like it's going to be a reversal at this point. And just for our interest here, just to bring us to attention here, the Eighth Circuit, of which we are located in, there were 4 cases decided, 2 affirmed, 2 overturned, a 50% reversal rate. About middle of the center in terms of court has been approaching things. But just also draw your attention here, the Ninth Circuit, which is considered to be the most liberal of all the circuits, which includes California and so forth. 10 cases taken, 4 were affirmed, 5 reversed. I think there was 1 dismissal out of there also too. Okay, so just bring it to your origin here. Historic statistics on reversal. Between 2007 and 2023, the Supreme Court released 1,250 cases. Of those, it reversed lower court decisions 800, 90 sometimes, 71% of the time, while affirming at this point lower court decisions 27.8 time. In that time period, SCOTUS decided more cases originating from the Ninth Circuit than from any other. Bottom line, the Supreme Court appears to be reversing the lower court at this point, and not a surprise whatsoever, I guess, if I sort of put that in here. Okay, now what we have here, just kind of fun here in terms of words spoken by justices at oral arguments, the 2023 term. And I'm not gathering these statistics, somebody else was, and makes me wonder who's got time to go compute all the number of words people speak here. But what becomes really quite interesting here is look who is the most vociferous person on the bench, and it's our latest justice on the court. And I just find this really kind of interesting because for many years, there was this sort of received wisdom argument that says that when new justices get on the court, there's what's called we used to call it the freshman effect. I'm not sure we can use those words anymore. Let's just call it the first termer effect. The argument used to be that justices were confused, they were bewildered, they were still finding their place on the court. And it would really take 2 or 3, or actually 2 or 3, 3, 4, 5 years before they kind of got into their own. Well, I just find it interesting that really right out the gate, our newest justice seems to be again quite vigorous on the bench in terms of where they are, and she surpasses at one point it was Sotomayor, who was contesting out with what Scalia at one point for the most vociferous on the bench, and so the speaking dynamics has changed a little bit. Again, here I provide a chart, and you at your leisure to look at this, with more time here in terms of who agrees with whom. And specifically, what I'm interested in here is levels of agreement, among the justices in terms of how they agree with somebody else. And so, for example, Gorsuch agrees with Thomas 71% of the time, Alito 68%, Barrett 61, Kavanaugh 58, Roberts 58. And again, just some interesting patterns here. But I think my next slide, I do some summaries. Yeah. Okay. The highest agreement was 94%, which applied to the following pairs, Sotomayor and Kagan. And so they're basically agreeing 94% of the time. Roberts had the highest average agreement rate with each of the other justices at 61%. Kind of not a surprise for the Chief Justice. The lowest agreement rate was 10%, which applied to the following two pairings, Thomas and Sotomayor and Thomas and Kagan. They don't see the world eye to eye, it looks like. And Sotomayor and Kagan had the lowest average agreement with each other 8 justices at 43%. So we clearly have blocks that are forming here. Again, just looking at how justices voted in 15 major cases, just to give us some kind of sense of where the justices were in terms of majority vote or minority votes. Just, again, interesting patterns here that Kavanaugh and Roberts seem to be in the majority more often. But if you look at the top 5, Kavanaugh, Roberts, Alito, Gorsuch, and then actually throw Thomas in, we can see a pattern here. A pattern of the 6-3s that I was referring to in terms of how the justices seem to be lining up here. And then, in case you're wondering how hard people are working at this point and what they're doing between the first Monday in October and the end of June, again, just sort of for the heck of it, looking at majority opinion writings by justice and by month, and thus basically how many arguments there were, and then how many opinions come out by each justice during the month. Take these statistics for whatever you think they may mean at this point, but just kind of interesting. So observations on case disposition. 34% of the cases, just about 5 more minutes, by the way, then switched over to Marshall. 34% of the cases were split 5-4. In the 2020 Let's keep saying 2023 term, supposed to say 20, except in 2022 term, it was 20%, highest percentage, by the way, of 34% split since the 2007 term. 35% of the cases were split 6-3. In the 2022 term, it was 45%. Of the 60 cases, merit cases decided 2023 term, 21 had a 6-3 vote. 6-3 seems to be the new 5-4 at this point. And 40% of the cases were 9-0. In 2022, it was for 45%. Again, just showing you us the lineup in terms of how justices are deciding and reinforcing an argument suggesting that there's a pattern there, a pattern that falls along ideological lines. Republican appointed and conservative justices of the court are more likely to overrule constitutional precedent. This is some of the research that I've done in the last couple of years on the Roberts Court. And again, I'm happy to talk more about it in more detail. But what we know is that there were a total of, what was it now, 16 cases the Roberts Court decided so far that have overturned constitutional precedent. And what we can show is that generally Republicans appointed justices are more likely to overturn precedent, and the more conservative they have been on the court to overturn precedent. And again, if anybody wants to ask me how I computed all that, I can do that later. Again, ideology matters. Appointing president matters in terms of splits here. Again, a disagreeable court. The 2020 term recorded a record high of 1.05 concurrences per case. What we're looking at here is not just dissents, but the sort of the predilection of justices to say, well, I don't completely agree with the majority. I got to write my own opinion. So a lot of ink being spilled on the Supreme Court right now. And then there were stories of Alito and Thomas, and some stories of Sotomayor of accepting gifts or not reporting income from friends or major donors, which continues to sort of raise questions about the court. And then the Trump administration in court, I just want to throw this in here, is that if we go all the way back, to what Roosevelt at this point and look at the success in terms of how successful the president has been, or the president's administration has been before the court. We will look at, for example, Trump having the lowest success rate and Biden really fairly low also too. So we're looking at the Supreme Court and the president not exactly seeing eye to eye. And I think at this point, what I'm going to do is stop for now. I'll come back to maybe talking about some of these cases later, a little bit more detail, but I want to stop sharing my screen and turn this over to Marshall for him to do his part of the presentation. But before we do, I want to check here and see if we've got any questions here before I move on. And hold on.
There is one question in the chat, and I think you answered part of it.
Okay, what percentage of cases in the last term came out 60, with 63 being conservative justice and 3 being the liberal? Doesn't that large amount of crossover suggest that political smiles doesn't play as huge a factor for justice? That's actually a really good observation, Marshall. Anyway, hi, Marshall. Is that not all of them came down 6-3? They certainly did not come down 6-3, but a high percentage of them did. And this is why I throw this out here, because for people who want to say it's all politics versus people who want to say it's all law, the evidence cuts both ways. And so I bring that for you folks to sort of reach your decisions on in terms of how to look at this. But it's a great question here. It seems like we've got Marshall here at a different score. Marshall Keller, we should be talking about baseball, but that's another day for another time or something like that. But anyhow, I turn it over to Marshall Tanick now.
And Marshall, I'm not sure if you're trying to speak right now, but I think you are still muted.
Marshall, we can't hear you. You have to unmute yourself.
We may be experiencing some technical difficulties here.
Would Sarah, would you like me to go back and do some more of my presentation and then see if we can figure out how to address the technicals?
Yes, I think that would be a great idea. I will stop sharing here for a moment.
Okay. All right. So let me get back to my screen. Just give me a minute here. Okay, so I should be up and running again, and I think it's full screen again. Okay, good. All right, good. All right, so where I was before, I was going to, discontinue for a second here, is that the other way I wanted to look at some of the opinions, in terms of the court this year, is Trump as private citizen in the court versus perhaps as a as the Trump administration. Because remember, a couple of screens back, I pointed out to you that if we were to go back to Roosevelt's time, not Theodore Roosevelt, Franklin Roosevelt, pardon me, Franklin Roosevelt, we see various levels of success in terms of the administration in court, where the Trump administration had a fairly the lowest percentage, going back to again FDR in terms of success before the courts. But also remember that Trump appeared in the courts, especially the Supreme Court, as a private citizen this past term. And so the two main cases, and I'm going to leave to Marshall time to talk more about these cases in more detail, is that the two, I guess the one I want to highlight here is Trump versus Anderson. And this was the case, or this was sort of what, beginning of 2024. This was exciting so many people. It was somehow the idea that the 14th Amendment insurrection clause, that is Section 3 of it, would allow states to keep Donald Trump off the ballot, because of the events that trace back to January 6, 2021. And what the Supreme Court said, again, I'll leave to Marshall Tanick here more time to sort of go into it here, is that the court rejected that argument and said that Congress must act to determine how and when the clause can be invoked, and states just can't invoke it on its own. And then Trump versus the United States was the case that came out in late June, which said individuals, I should say, individuals enjoy immunity from criminal prosecution for the performance of official acts performed while serving as president of the United States. This was the major case growing out of especially DC, involving, again, January 6th. For those of you who want sort of highlights at this point, the cases are essentially over at this point, with Jack Smith stepping down and so forth. But these were two big wins for Donald Trump as an individual, I would say. Okay, hold on a second here, just a second. Oops, sorry, got to go back. Yep, tried. Okay, Joe Biden's court packing plan. You might remember last year that Joe Biden decided that he wanted to propose a constitutional amendment that would do or several things in terms of his what I call court packing plan. First, a constitutional amendment to overturn Trump versus the United States. He also wanted to have legislated a mandatory ethics code for the Supreme Court. And he also wanted a constitutional amendment to limit the Supreme Court term
Hello, hello.
18 years. Oh, we can hear you now.
All right, hello.
Hello.
The computer in our neighborhood has gone out. We're out. Can you hear me, folks?
Right? Yes. Yes.
All right. I can't see. I can see David. Sarah, are you there?
Yes, I am here.
Okay. So
all right. I'm gonna try to do what I can here, and I cannot see the screen. Can I be heard, everybody?
We can hear you, and I can share your slides.
Okay, so I'm going to stop my share. By the way, Sarah, hold on a second.
and I can't be. Can I be seen?
We cannot see you at this point.
All right, we're gonna. All right, I can't. My machine's dead, but I'm gonna talk the old-fashioned way. So, Sarah, I will say flip the page, and I'm sorry about this, folks, but my computer just died, and I'm told the whole neighborhood where I'm in has lost their internet service about 20 minutes ago.
Oh,
Okay,
goodness.
no, it happens. It happens. All right, and I can't start my video here, so we're just going to talk this through. Hello, everyone. Marshall Tanick, and I'm going to be talking about some of the specific cases here. I just want to add a couple of thoughts to what David said. David is correct that Jimmy Carter was the only president besides one of the only presidents besides William Henry Harrison, the 30-day president, who did not appoint a Supreme Court justice. But there were two others. Zachary Taylor also did not appoint a Supreme Court justice. He had a short term, 2 years before he died in office. And Andrew Johnson, who succeeded Abraham Lincoln and served the rest of his term, also did not appoint a Supreme Court justice. So that completes that category. I'm going to talk about some of the cases here that were significant during the past year. And I hope you have my cover page there. And I'd say flip the page to the table of contents. And again, I'm informing people that I cannot see the screen. But there's our table of contents. Oh, I can see the screen. Now I can. Okay, great. Thank you, Sarah. So, and we're going to start by talking about a couple of the abortion appeals on the next page that'll be flipped. Can't see the screen again. Okay.
Marshall, I think you're muted. We lost you here again. Sorry, folks. Thanks for bearing with us while we figure this out.
While we're waiting to figure this out, this is David again here. I'm not going to go further in my presentation for now, but while we're starting to figure this out here, does anybody have any other questions they maybe want to ask or some observations at this point, in terms of some of what I've talked about, or just sort of maybe some thoughts about the sort of where the court was, or what I'm fascinated by is the statistics that I gave you before, just in terms of the composition of the federal bench at this point, district court, court of appeals, and so forth like that. Just in terms of the fact that with the court only accepting about 60 cases per year, no surprise that the lion's share of the work is being done at the district court, which it should be. And most of the appellate work is being done at the Court of Appeals level. And at least for now, again, if you think it matters here, that we've got the Democrats having a slight advantage. It don't sound like a sports contest we're talking about here. The Democrats have an advantage right now in terms of how it sort of plays out in terms of the compositions of the benches here. So Lori posed a question: would be curious to know if there's a movement afoot to require term limits for justices or require them to age out, or am I just hearing it on Facebook? Well, there is, again, Joe Biden made that proposal. There's been several people, who have argued for years, both on the Democratic side and the Republican side, that perhaps court has gotten beyond its judgment role. What I mean by that is go back to the Alexander Hamilton law school model here, that the court is supposed to just be rendering opinions. What's the Justice Roberts line? My job is not to pitch and bat. My job is not to pitch and bat. My job is just to review, or do I pitch and bat? My job is call ball and strikes. I'm sorry for a second. But people are saying, well, maybe the court actually is acting more politically. One of the screens that I did not put in today was really the declining faith and trust in the Supreme Court. That if we would go back to the 1970s, we were looking at the Supreme Court trust in the Supreme Court was what, 70, 80%. Even before the Roberts Court, it was still quite high. We're like 60, 70%. In comparison, the presidency maybe in the 40s or 50s. Congress, trust in Congress, never has been higher than 30%, sometimes down as low as 10%. But what I'm getting at here is that the public, especially after Dobbs, has lost a lot of faith in the court. And we're seeing a push, from the Democratic side for term limits, much in the same way that we saw a few years ago from the Republican side, a push in reaction to what, let's say, the Warren Court, the Berger Court, and so forth, to try to do term limits also too. So my point being is that there seems to be this ongoing churning out there, in response to what many people are perceiving at this point as a court that's really acting way beyond the role that's supposed to act in terms of, and therefore recognizing, I guess, how I described it to my student, as I said, what the public seems to be saying is, if we can't depoliticize the court, if we're going to accept the fact that the judges and justices are politicians wearing robes, the best that we could do now is what? Limit how many justices perhaps any president can pick, how long a justice can sit on the court. I mean, we're looking at a point now where, if we went back to the 1950s, the average time that a justice served on the Supreme Court, actually 1950s, 50s and 60s, was 12 years. Now we're looking at it nearly approach 20 years at this point. So there's a lot of concern out there about justices maybe overstaying their welcome, being too political, and we got to do something about it. So I'm going to scroll back here, and I just want to make sure that Sarah keeps me appraised in terms of where we are in terms of fixing technical stuff here. Lauren asks, out of curiosity, how long does an appointment for the district court and appellate court take? I'm curious to see if the amount of judges appointed by Biden remain relatively even, or if there's a bigger swing shortly as Biden closes out his term. Like I said, right now, we're probably going to see no more for Biden, that the new Congress sworn in. Pretty much, I don't think the Senate is going to confirm anybody between now and the 20th of January. Trump takes over. But there was a fairly significant flurry, and I'm forgetting what the exact number was, after Election Day until the first of the year, just a few days ago, in terms of the Democratic Senate trying to confirm as justices as possible. Now, what you're asking is also an interesting question here, Lauren, is how long does it take? Well, one measure is from the time of appointment being announced to confirmation. This could take months, if not, some people are saying in some cases it takes off over a year. I've not seen a recent statistic, but by the time background checks are done, vetting is done, and so forth, it takes well over a year, oftentimes, for some of the lower court justices. We're looking at Supreme Court justices, what, in the last few years, it's a few months. I'm forgetting the exact number, but I'm going to probably six months to a year is probably the norm for filling lower court appointments. Again, by the time we go from vacancy announced to person being nominated to vetted to Senate hearing and so forth like that, this is dramatic longer than it used to be 40 or 50 years ago. But it also speaks to how the nomination and confirmation process has become so political. I mean, this is the whole thing that's happened post Robert Bork, post Clarence Thomas, is that the whole process has become so politicized now that even lower court picks are dragging out. And this is why some people are saying that, well, if the whole process has become political, if the selection process is broken down, then maybe if we can't put the political genie back into the bottle, so to speak, what we have to do is instead recognize the politics and now figure out a way of how to work with it. So that's a possibility here. Okay, I'm going to scroll down here, and again, get to Scott here. Could at least some of the slowdown be on the part of the chief to try to get Congress to take more public policy work than the court? This is an alternative theory that I'm glad you brought up here, because I would argue, and some other people would argue this too, is that partly the reason why the Supreme Court has become so powerful, especially let's say in the last 30 to 40 years, maybe, is because the the Congress and the president have become so polarized and they're just not getting a lot done at this point. I mean, we can really look at statistics in terms of how in the last, I don't know, 10 to 12 years, uh, if you view passing legislation as a good thing, and certainly not everybody does, but if you were to look at it from that perspective, Congress has had decreasingly less and less legislation adopted in the last few years. Last Congress, I think, least productive might have been since World War II. And the percentage of straight party line votes is at its highest and bipartisan legislation at its lowest. But the point being is that I don't know about you, I could think of a half a dozen or a dozen really important things I would really like Congress to address, and they're not getting to them. And so by default, does this mean that people go to court? Go to court instead and ask the court to decide issues that might very well be appropriate for the political branches to decide? That's a really good argument out there in terms of it. Sitting on my bookshelf behind me is this wonderful book called "The Myth of Co-Equal Branches." You know that I've had arguments with my colleagues in law school, and I say, and they always use the phrase, and the Supreme Court says it. Well, we got three co-equal branches of government. No, no. The fact that in Federalist 78, Justice, or rather, again, Alexander Hamilton said the court would be the least dangerous branch, suggested it was not supposed to be co-equal. And in fact, the original plan was legislative supremacy, president second, courts third. What I'm getting at here is that one could make a good argument that maybe a lot of what the court is doing is stuff that it shouldn't be doing, and that partly what Roberts is doing is pushing the stuff back over. Except if that's the case, there's a presumption that generally policy should be upheld, passed by Congress, unless it's clearly unconstitutional. You know, this is the whole concept of fractional basis review. And there are some who would argue, and there's some statistics out there that we could look at, pretty good data that points to a political ideological bias under the Roberts Court in terms of legislation upheld or struck down. Again, I don't have all the statistics in front of me because I wasn't anticipating a technical glitch here, but there is stuff out here. Okay, could you comment on the ethics issues, particularly regarding the conduct of spouse part of justice, and the current ethics rules adequate to cover these situations? You know, if I look at, for example, if I can sort of work on this a little bit longer, if I look at, for example, for members of Congress, I'll even do the state legislature in Minnesota because I'm more.
I'm back. Can I be heard?
Okay. Okay. Let me just finish my answer to Lori and then get you to you, Marshall, here. Okay. If I look at the statements of economic interest that oftentimes occur at other levels of government for other branches of government, it does include immediate family, children, spouse, and I don't think it's unfair to include that in there. I'll have Marshall comment on this eventually also too. I don't think right now that the current rules are really working well because what? The court has to self-enforce itself, and apparently it's not self-enforcing it. And two, we don't have a full picture. Now, stories have come out about Clarence Thomas and his wife. I have no idea what the information is regarding the other justices and their significant others. It would be really interesting to find out. So, you know, from the days when I was involved with Common Cause Minnesota, I used to always say, maybe I agree, is it Brandeis's argument that what transparency is the best disinfectant? I always say, let's have disclosure first and figure out what's going on. But anyhow, I'm going to end my talk a little bit now for here and turn it back to Marshall. Fingers crossed that we're back up and running with him. Go ahead, Marshall.
Hello. Where was I, Sarah? My machine is doing some very strange things. So can someone tell me where I was? At least.
Yes, so we've got you still on the slide on the abortion and birth control
Oh,
pills, so the FDA slide.
that's my very first one, right? So I was talking for the last 20 minutes. I've been talking. No one's heard me, right?
I think so, unfortunately.
Okay. All right. All right. Here we go, folks. We're starting over again. On the abortion appeals. All right, David said that abortion is safe for now, and there were two big cases decided by the Supreme Court, abortion cases decided by the Supreme Court last year. Both of them are still alive and well. One of them is on the screen now is the FDA the case of the Doctors for Hippocratic Medicine versus FDA. That's a challenge to mifepristone, uh, the birth control pill, mail order birth control pills. That was decided by a judge, a federal judge in Northern District of Texas, in a judge shopping situation in which he ruled that the FDA did not have a proper authority to allow the mifepristone to be administered through the mail and sent through the mail. So he overturned 20 years of FDA regulations on that. The case reached the Supreme Court. The doctors who were challenging that measure claimed that these were anti-abortion doctors, and they claimed that they suffered emotional distress in knowing that some of their colleagues were providing abortion medication. They didn't claim any personal injury, but they claimed that it bothered them that some of their colleagues would order prescription birth control pills. The Supreme Court threw that case out on lack of standing. The Supreme Court said the doctors did not have standing to claim emotional distress against the FDA. So that pretty much put that case to rest for a short time, because three states, Missouri, Kansas, and Idaho, have joined together in a lawsuit recently filed in the state of Missouri by the Missouri Attorney General, in which he is challenging the FDA allowance permission of mifepristone birth control pills on grounds that they are not safe. So they are challenging it on a safety basis. In other words, challenging the administrative allowance of birth control pills by mail. The case just started in Missouri, and it'll probably take a while before it germinates and goes through the Eighth Circuit and perhaps reaches the Supreme Court. But the Supreme Court is going to have an opportunity to take another look at mail order birth control pills, having rejected this argument by the doctors for lack of standing. Meanwhile, the Comstock Act comes into play. As many of you know, the Comstock Act is an 1870s law that prohibits the use of the mails to disseminate lewd, obscene, pornographic material, including, or I should say plus, birth control materials or any birth control information, data about birth control. And there are some of an anti-abortion ilk that have advocated for using the Comstock Act to ban birth control measures, not only birth control pills, but information about birth controls, where to have birth control, where to engage in, where to have abortions, any kind of data through the mails or through the internet. And that provision is one of that contention to use the Comstock Act is one of the provisions in Project 2025, the 900-page handbook for the new incoming administration. So we'll see how that plays out. The next abortion case on the next slide is the Idaho case. There it is, Moyle versus United States. That's a classic case of states' rights versus the supremacy clause. Idaho has among the most restrictive birth control, abortion laws in the country, probably the most. Under Idaho law, an abortion cannot be had unless the mother is unless it endangers the life of the mother, not the health of the mother. No abortion unless the mother is dying. That's the Idaho law. Under federal law, there's a federal law known as EMTALA, Emergency Medical Treatment Law, that says that any agency, any organization that receives federal funds, medical funds through Medicaid, must allow emergency treatment. And so the feds sued Idaho to allow abortions under the federal Medicaid law. The case reached the Supreme Court, took cert on it, and then dismissed the case as cert improvidently granted. So the clash between the Idaho no abortion law and the federal requirement that abortions be allowed in federally funded facilities, which is just about all of them, remains unresolved. However, the case is going to trial. In fact, it was tried last month, and testimony has been taken in that case. and the district court will issue a ruling probably sometime relatively soon. That'll make its way could make its way back to the Supreme Court. So the Supreme Court may be taking another look at that clash between the Idaho no abortion law and federal law. And this doesn't only apply to Idaho. That same concept would apply to most of the states that ban abortions, insofar as they almost all receive some type of federal funding. So it's a very important case, and we'll see how it plays out. The next case on the next slide is the Loper Bright Enterprises versus Raimondo, and that's the case that overturned the Chevron Doctrine. The Chevron Doctrine is a 40-year-old doctrine that basically provides for courts to defer to administrative agencies in rulemaking or regulation. Administrative agencies, the federal and state systems are rife with administrative agencies that do rulemaking and regulations that affect the day-to-day lives of people and businesses. The FDA, the FTC, the airport, the FTC, the Federal Communications Commission, all of these various alphabet organizations, many created by the New Deal, engage in rulemaking and regulation. Since 1984, the ruling in the Chevron Doctrine is that those administrative agencies should be given deference, and it's very hard to successfully challenge an administrative agency, regulation, or rulemaking. Not anymore. In the Loper Bright case, the Supreme Court reversed 40 years of law and said that administrative agency decisions are subject to de novo review in the court system. De novo review, no deference at all. So that allows anybody who has been subject to administrative regulation or rulemaking to challenge that rulemaking in a fresh case before the federal courts to start the process all over again. That's a tremendous boon to the business community, that is usually the ones who challenge administrative regulations. What it means is that administrative agencies have very little, they have power, but their power is greatly diluted because any party can challenge their decisions, go through the court system and probably drag out the proceedings for 2 or 3 years and maybe get a better result as well. So the Chevron Doctrine, which provided for administrative discretion, for administrative deference, is no longer in place, and any administrative ruling in the federal court system is subject to de novo review in the federal court system, which is going to significantly retard the ability of agencies, the NLRB, the FAA, the FDA, the FTC, and all of the alphabet agencies to do their work. Some observers, including me, have said that notwithstanding the high-profile cases decided by the court during the last term, including the Trump versus United States case, which I hope we'll get to in a couple of minutes. Notwithstanding those cases, this case, the Loper Bright case, may be the most significant, have the greatest long-lasting impact in substantially changing how the American administrative process works and the judicial process works as well. An example of that is the next slide, SEC versus Jarkessi. That's a SEC case involving the ability of the SEC to enforce compliance with SEC securities laws. Most of these agencies that I've just mentioned, the FTC and the NLRB and the FDA, have their own internal system for patrolling and enforcing their regulations and laws. In a civil enforcement proceeding, the Jarkessi case holds that if an agency seeks to impose a fine for a violator, a civil fine, not a criminal fine, but if an agency seeks to fine a business or an organization for violating its own regulations or its own rules, they must give them a jury trial under the 7th Amendment. That's a huge change in how administrative agencies have handled their business before, and it means that the ability of administrative agencies to enforce civil remedies, in terms of monetary fines, is significantly, if not irretrievably, altered. And we're going to see how that plays out with all of these various federal agencies. And while these cases I've just mentioned, the Loper Bright and the Jarkessi case, both are federal cases, it certainly is likely that the same rationale may be applied at the state levels too, dealing with state agencies and state regulatory agencies here in Minnesota, like the PCA and so on and so forth, Environmental Rights Council, and various administrative agencies. These two rulings just significantly dilute their ability to do their work. Another example of that is on the next page, Starbucks versus McKinney. This is an enforcement action by the NLRB in regulating union elections. Starbucks has been subject of a lot of union elections and attempts to organize. And in the past, the NLRB has had the ability to step in and enjoin businesses who are violating union organizational rights or interfering with elections if there's reasonable grounds to believe that there's some violation. That is no longer the case. In the McKinney case, the Supreme Court held that in order for the NLRB to prevent or enjoin interference with a union election, they have to show that there's a likelihood to succeed, sort of the injunction standard. But it really elevates the requirement to enjoin interference with union organization, and it makes it much harder for the NLRB to oversee union elections. Another example of the dilution of the powers of administrative agencies that was the hallmark of the past session of the past term of the Supreme Court. I'm going to skip ahead a few pages here because of time and go to bump brouhaha. We're going to skip ahead here. I hope that the slides are available to people. I think we make them available to folks anyway to look at, but because of the time constraints here, I'm going to jump ahead to a couple of the gun cases. Garland, that's Merrick Garland, versus Cargill was the bump stock case. This is a regulation enacted during the first Trump administration after the horrific Las Vegas mass shooting, which injured or killed almost 500 people. The Bureau of Alcohol, Tobacco, Firearms, and Explosive, another administrative agency, enacted a regulation that prohibited the use of these bump stocks, which essentially allow ordinary rifles to be turned into machine guns. The Supreme Court, in a decision by Justice Thomas, said no, the agency went too far, and it was not classifying bump stocks as machine guns under the applicable law is not reasonable, and therefore bump stocks cannot be prohibited by the administrative agency. Justice Alito pointed out that this was not, in a concurrence, pointed out this was not a Second Amendment decision. He said this is just an administrative regulation. When we've seen how administrative regulations have been diluted, but Justice Alito said Congress could always act if it wishes to ban bump stocks. Well, good luck on that politically. It's not going to happen, and therefore bump stocks are permissible and probably will be for the foreseeable future. Another marquee case from last term is the next slide, the Rahimi case, and that's the next slide is the Rahimi case. And that was a marquee case. That's that is the federal law, 18 U.S.C. 922, that prohibits felons to have possession or purchase guns, firearms, but it also extends to anyone who's under a domestic violence order. It's a federal law that makes it a crime for someone under a domestic violence order to have a gun. In this case, someone did that. A person who was under a domestic violence order in Texas was subsequently involved in another altercation. He was arrested and they found a gun on him. So he was charged with possessing a gun while he was under a domestic violence order. He challenged that under the Second Amendment. And many analysts or observers, including me, thought that would be kind of a slam dunk and that the Second Amendment challenge would prevail based upon the previous year's decision in state rifle and pistol versus Bruin. As many of you recall, that's the case that threw out the New York licensing law on grounds that under the Second Amendment, because there was no, quote, historical tradition of regulating, requiring licenses for guns. And the court established this doctrine, which was also used in the Dobbs case, which was decided one day after Bruin, where the court looked to a historical tradition to determine the Second Amendment. In the Dobbs case, it looked to a historical tradition to some extent to decide abortion rights. But in the Bruin case, the court said the focus on gun regulation or gun legislation must be on whether there's a historical tradition of that kind of legislation. There wasn't in the Bruin case, so the licensing law was thrown out. as I said, many people thought the same thing would happen in the Rahimi case, but they were wrong. Chief Justice Roberts wrote the decision, and he kind of navigated between the historical tradition doctrine and the concern about having domestic violence abusers have access to guns, and he came up with sort of a new standard. He said, we don't have to find something that's identical in history to this kind of regulation in order to sustain it. We just have to find something that's, quote, relevantly similar. I hadn't heard that term before. I'd never heard the term relevantly similar, but Justice Roberts said in determining the permissibility of gun regulation under the Second Amendment, one has to look historically to see if there was something that sort of was like that in the past. In this case, there was, so they upheld the prohibition. There's a couple other gun cases brewing that probably may reach the Supreme Court that'll test the Bruin doctrine versus the Rahimi doctrine and see what's relevantly similar or not. One's the age restriction. That's a Minnesota case, but there's cases in other jurisdictions in which the state laws have restricted sale of guns to people under 21. As many of you know, in Minnesota, that law was thrown out by the federal court and upheld by the Eighth Circuit, affirmed by the Eighth Circuit that the Minnesota age prohibition on gun ownership is violations of the Second Amendment on historical and traditional grounds. There's other cases like that in other jurisdictions that may reach the Supreme Court soon. And and also the felon in possession law has been challenged, and there's several Eighth Circuit cases and some split in the circuits as to whether the felon in possession law offends the Second Amendment. Most courts have upheld the felon in possession law under Second Amendment challenges, but there is some other decisions that cut the other way, and both those cases, age restrictions and felon in possession cases, may end up before the Supreme Court probably next term. Let me skip over a few more things here for timing purposes, and let's go to the Trump cases here at the end here. Tourist rioters and patriots. Almost done here. Tourist rioters and patriots. Yeah, there we go. There were several Trump cases decided by the court this year. One of them was this case, the Fisher case. And Fisher challenged the conviction of January 6 rioters, the riots that took place 4 years and 1 day ago, under one of the federal statutes that they were charged. That was the Enron statute. The statute enacted during the Enron days, Sarbanes-Oxley, makes it a crime to obstruct an official proceeding. Many, not all, but many of the January 6th rioters, or some would call them heroes and patriots, were charged under for obstructing an official proceeding. The Supreme Court held that statute did not apply because it only applies to destruction or concealing documents like the Enron case. It does not apply to physical conduct that obstructs an official proceeding. So many of the January 6th rioters had some of their convictions reversed, although they were charged on other grounds too. But nonetheless, this case significantly erodes some of the convictions of the January 6th rioters. But it all may be moot in a couple of weeks anyway, because President Trump has said that in the first hour after he's inaugurated 2 weeks from yesterday, he will pardon some, many, most, or all of the January 6th rioters. Next case, let's go forward here to a couple more Trump cases, and we'll get to the big one here. And let's go to Trump Trio. Trump Trio. Okay, here we go. One case that really went under the radar, but it's a Trump case, is a Democratic activist wanted to trademark the term Trump too small to sell on T-shirts. The Trump too small phrase, as many of you recall, refers to the 2016 campaign in which he and incoming Secretary of State Marco Rubio engaged in a very sophisticated, thoughtful discussion of the size of their respective body parts. And the Democratic activist wanted to sell T-shirts with the term "Trump too small" on it. He was denied a trademark for that by the Trademark Board of Trademark and Patents, and the Supreme Court upheld that. They said that the history and tradition, there they go again, requires that only if a trademark's in someone's name, it has to be the person's name. You can't trademark something in someone else's name. So he could use the Trump too small T-shirts or he could put them on sweatshirts or T-shirts or sneakers or whatever he wants to do, but he can't trademark it because Trump alone owns a trademark to use his own name. And that's why he can sell Trump cologne too, and all these other Trump things. Only Trump can put the Trump name on his Trump products. A couple more Trump cases. The ballot battle, remember that? It seems like it was decades ago. Can Trump be removed from the ballot under the 14th Amendment insurrection clause? The 14th Amendment has a clause that says anyone who engages in or aids and abets an insurrection is disqualified from holding federal office. Several states addressed issues of whether that provision applies to President Trump, or President-elect Trump, in connection with the January 6th riot, and they held that the Minnesota Supreme Court ruled that it was premature. It wasn't right because the case was brought before the election. Colorado and Maine allowed challengers to remove Trump from the ballot under the insurrection clause. Went up to the Supreme Court. No, they said the insurrection clause can only be applied if Congress passes a specific law. So the provision in the 14th Amendment that bars those engaged in or aiding and abetting insurrection is basically read out of the 14th Amendment in itself, and it requires it becomes an enabling law for Congress to legislate, but it's not self-activating. And then we get to Trump versus United States. That's the biggie. Everyone knows about that, so I'll only spend a moment or two on that. But the issue there was whether President Trump is immune from criminal charges. The case arose in the election interference case in Washington, D.C. That was one of the several cases against President Trump at the time. And most of the observers and the wise people and all these commentators that are on television and all that, most of them laughed at the argument. And I don't know most, but many said that it's a frivolous argument. The Supreme Court wouldn't even take the case. And not only would they take the case, they may even sanction the lawyers for bringing such a ridiculous case and making the argument that the president is immune from criminal laws that apply to everyone else. They were wrong again, and the Supreme Court did take the case, and we all know what they said. Chief Justice Roberts wrote the decision 6-3, and he said that a president has immunity for official actions within the scope of his constitutional duties. He referred to the core duties of the president, which are pretty broad. In fact, one clause in the Constitution says the president is obligated to, quote, take care that all laws be faithfully executed. And that opens up all kinds of opportunities for a president to say he's acting within his official duty. The highlight, of course, was the argument about SEAL Team 6. The argument at the lower courts was whether the issue at the lower courts is, well, could the president be immune from ordering the military to kill a political rival? And Trump's attorneys argued, yeah, probably so, because his official duties extend to being commander in chief. Well, the Supreme Court didn't go quite that far, yet, but they did say that the president's powers are very broad under the Constitution. Anything that the president does, with some exceptions, with very few exceptions, but anything that the president does that's carrying out his, quote, official, unquote, duties warrants immunity from criminal prosecution. We'll see how that one plays out, but it ultimately led to it ultimately underlined the dismissal of all of the other cases against President Trump. Although the Georgia case, I guess, is still alive, but the Mar-a-Lago documents case was dismissed on other grounds as well. Incidentally, just take a moment here. Incidentally, because the president now has criminal immunity for any violations within his official duties, let's take a look at that confidential classified documents. A president now, official duties of the president is to handle classified documents. Under the Trump ruling, a president is immune from violating any laws concerning his official duties. Therefore, a president could possibly take any documents he or she wants under their official duties and do whatever they want with them. They can take them into ballrooms and put them in bathrooms, or flush them down the toilet, or sell them to an adversary, or auctioning them off on TV, or selling them on TV. How about that idea? Trump sneakers and Trump guitars, and throw in a few classified documents as well. because the Supreme Court decision in the Trump case immunizes the president from any actions, criminal actions, in connection with any duties prescribed in the Constitution. So that ruling is extremely broad, and some have said that it's one of the worst rulings ever made by the court. I won't go that far. I'd say Dred Scott ranks up there as number one, but on a personal level, I'd put this as a close number two. So that's my view of some of the key cases from the last term of the Supreme Court, and I'll send it back to David, and maybe I'll return, and maybe I won't, to talk about what's coming up this year on the current term.
Okay, great. So I'm going to share my slide again, and I will probably just go for a few minutes here and turn it back to Marshall so that he can talk about what's coming up, because how we originally had the division of labor set up here was I was going to here we go. Good. I would do the discussion of the current cases in general. Then he was going to go into more detail, but I was mentioning some of the cases that he was going to go talk into more detail about. So I may just sort of skip over this pretty quickly here. But where I was in my slide, again, for those of you, we have to do an apology again for some of our technical difficulties today. And what's the old joke? Technology works great, except when it doesn't. Is that I was finishing up on the Joe Biden's court packing plan. And again, the efforts to try to address some of the ethics issues and to try to address what is a perception that the American public has now, that the court has become too political, has become too powerful, that presidents could really extend their legacy for many, many years through who they appoint to the Supreme Court or the district courts. And so Biden's effort to try to say, well, let's overturn Trump versus the United States. Let's have a mandatory ethics code that's enforceable on the Supreme Court, and an amendment that limits the Supreme Court to a term of 18 years would be ways to do it. And the 18 years proposal is the idea it wouldn't apply to any current justices. It would have to apply going forward. It would work out that barring deaths, et cetera, each president would be able to appoint 2 justices to the court in a 4-year period. And the idea being that over time, you would have a situation where every president gets to sort of put on his or her justices. Except the problem is, as we know, justices don't always stay on the court. They die, they resign early, et cetera, et cetera. So I know I talked with my students at one point regarding how viable this as a proposal was. I'm just not sure it was really in some ways in terms of being able to address some of the ethics issues. Again, cases that I would have put on my list of top decisions, and Marshall already covered many of them here. City of Grants Pass, Oregon versus Johnson. The enforcement of generally applicable laws regulating and camping on public property does not constitute cruel and unusual punishment prohibited by the Eighth Amendment. Clearly, this is going to have a big issue, especially in Minneapolis, where we do have a pretty significant encampments, and there's been struggling to try to figure out how to address the issue of homelessness. And I know after this decision came out, there were actually several municipalities across the state of Minnesota that were saying that, well, maybe what we could do is enforce criminal laws and arrest people who are camping on public property as a way of addressing the homeless issue, or what they perceive as a public nuisance issue surrounding public camping. We'll see. The Menez decision, again, U.S. citizen doesn't have a fundamental liberty interest in her non-citizen spouse being admitted to the country. Again, just an interesting case all about the all about really about immigration. The two social media cases limiting the ability of states to regulate the content of social media sites, which becomes, I think, even more interesting in light of today that Zuckerberg and Facebook announced that whatever fact checking they were doing on Facebook, they're going to end it. And we're going to get to see what kind of implications they have. I'm going to skip over these cases that Marshall talked about in terms of what the pistol packing trio of gun cases, the regulatory authority cases. Again, we've already talked a little bit about these. They include a series of cases beyond the Loper Bright, in which what we had is kind of a mixed bag in terms of the court looking at authority of regulatory agents to be able to act, to be able to enforce their rules, or whether or not they even have any authority to be able to be in existence through their funding. So again, I will kind of pass over those because I want to get back to Marshall in a couple of minutes here to talk about where we're headed in terms of this term here. Again, for administrative nerds like me, Loper Bright is gone, but just to sort of be really, really nerdy here, what the court does suggest at this point is that with Loper Bright gone, that the excuse me, the courts will use Skidmore deferences, persuasiveness. So what the court's going to now say is that we're not going to do Chevron deference, but we're going to use Skidmore deference and say that we'll give an administrative agency's interpretation of the law persuasiveness deference, but not what, let's say, conclusive. Also point out, and the court pointed this out in Loper Bright, it had been almost 8 or 9 years since this court had used Chevron deference. And so you could sort of see it coming for a while out there. Again, Marshall talked about the abortion cases. I can sort of pass over those again. And then just in case you're wondering where I get some of my information here, a variety of places. SCOTUS blog is always good to look at. Empirical SCOTUS is good. That I also drew from New York Times, Ballotpedia, and The Guardian. So I do want to turn it back to, by the way, I do want to turn it back to Marshall because in the few minutes that we still have here, I think he would like to talk about some of the big cases that are coming down the line this term. So hopefully all this will work again where I stop sharing, turn it back to Marshall, and he gets to talk about the preview of coming attractions.
Thank you very much, David. I'm back, I guess, and we'll go to my portion that says 9 more for 9. There we go. Okay, I'm going to skip. I'm going to do the lightning round here for some of these.
You're LTD, right?
Yeah. Say again. Can I be heard?
Yes, you can. Go ahead.
Okay. 9 for 9, lightning round. Some of these cases have already been argued. None has been decided, I don't think. I don't think the Supreme Court has issued any decisions in any of these cases yet. Ames versus Ohio Department of Youth Services, big case, reverse discrimination. A woman claims that it's an employment case. A straight woman claims that she was passed over for promotional opportunity in favor of 2 LGBTQ employees. It's a reverse discrimination case. It follows on the heels a few years ago of the Supreme Court case in Bostock, in which the Supreme Court recognized that LGBTQ plus classification is covered by the 1964 Federal Civil Rights Act. And this is the natural sire of that case as to whether there can be a reverse discrimination claim against LGBT individuals. Free Speech Coalition versus Paxton, that's the Attorney General of Texas, Ken Paxton. This is another one of the website cases, internet cases. It's an important one. This is a Texas law. There's one in Florida too that requires website users to be notified of content that's, quote, harmful to minors. Significant impact this could have on access of minors to internet material, depending upon how the term harmful is construed. Some have said, well, that's pretty limited. It's going to be limited to pornography and obscenity. Some say, well, it could be limited to ideology concerns as well. I'm skipping down here. The Barnes versus Felix case is an important case for police brutality claims. It concerns a time period, the statute of limitation for excessive or extreme or excessive force cases in police brutality or police assault cases. Next page, ghost guns. The next page here is ghost guns, regulation of government. This is regulation of ghost guns by the AFTE, Alcohol Bureau, the Alcohol, Fire, and Tobacco Bureau. It's a big issue in terms of the Second Amendment, and we'll see how those Second Amendment precedents play out in this.
Okay, we could go take a nap.
Louisiana versus Collis is yet another one of the racial gerrymandering cases. They're kind of all over the map, figuratively and literally. The Supreme Court has ruled against racial gerrymandering in Alabama and Louisiana, although this case is coming back from Louisiana. But last term, the Supreme Court in Alexander versus NAACP gave South Carolina a pretty free pass in terms of gerrymandering that has a racial implication. And it would appear that from that decision, the Supreme Court is less interested now in getting into racial gerrymandering cases, having already decided not to get into political gerrymandering cases. So it may well be that this case puts the nail in the coffin on the Supreme, at least at the federal level, of courts addressing gerrymandering cases, even on racial grounds. A couple of interesting death penalty cases, Gutierrez versus Sands. This is whether a death row inmate is entitled to DNA testing. That was argued a few weeks ago by the Supreme Court, and see how that plays out. And the Glossop versus Oklahoma case is really interesting. This is a man on death row who's challenging his upcoming execution, and the state is joining him. The state is agreeing with the prosecution, agrees with the condemned man that he should not be executed because there were significant improprieties in the trial court. So we have a case where the prosecution and the defense both agree that he shouldn't be executed, yet he's still on death row, and the Supreme Court will have to determine whether the prosecution's objections to its own prosecution override the death penalty in that case. And my last page is a final as a sayonara. Here, next page. See you next. I hope I see you next year. Maybe you'll hear me next year, and maybe you'll be able to see me next year, depending upon how the internet connection works out. That's what I have, David.
May come back here. Okay, so let me throw out a couple of thoughts here, Marshall. Ask you a couple of questions here, and then see if anybody else wants to sort of chime in on this. The two areas where I think the Supreme Court has created the biggest mess for itself in the last few years is in terms of abortion and in guns at this point. There's kind of this old phrase that says, don't wish for something, you might actually get it. The court has now said, that states are free, to be able to regulate abortion. Sort of thinking that, well, they're going to wash their hands completely of the abortion issue. But yet I don't see these cases ending. And in fact, I see a continued steady stream of cases all about birth control. I suspect we're going to see a Comstock Act case come before the Supreme Court at some point. So I see a variety of those that are coming there. And in terms of the guns, where the court has gone now is to say, we're going to judge or make a determination regarding whether a gun regulation is constitutional by looking at longstanding traditions. And this longstanding traditions now is again creating problems for them, because how do you now look at a case, for example, regarding the regulation of ghost guns? And say, well, what's our long-standing tradition out there in terms of regulating ghost guns? And so I sort of want to throw it back to you in terms of what are your thoughts on this? Because I think it's abortion and the guns, and I'm going to now add to it. It's going to be the Loper Bright, that they're going to suddenly be flooded with tons of administrative law cases and having to sort through all this stuff in ways that I don't think they anticipated. But what are your thoughts?
Well, since I have 1 minute, I'll say this. I agree with you. As indicated in the Mifflin case and the Idaho case, the abortion issue is going to be litigated in a number of different contexts, federal versus state issues. And I pointed out, as you did too, the Comstock Act is going to come up. It's going to rear its head, and it's going to be litigated as to the birth control pills. So I agree with you. I think abortion is going to be a hot issue for years to come. Likewise, the guns. The age restriction I mentioned in the Worth versus Harrington case, that's a Minnesota case, felon in possession. I think there's, I won't say open season, but I certainly think that just about any kind of gun regulation is subject to a vigorous challenge. And I think there's at least a 50-50 chance that just a challenger, maybe more than that, a 50-50 challenge, 50-50 chance that any challenger can prevail on a historical tradition argument, maybe on gun issues. And as I indicated, and I agree with you that the Loper Bright case opens up just a floodgate of potential administrative actions. One other area I think that might be of some concern, there won't be a lot of it, but the way that the court has really lessened the enforcement of corruption laws. One of them came up this last term in Snyder versus United States. It's in my material. In the Snyder case, a mayor of a relatively small town that granted a $1 million contract to a garbage hauling company, then received a $13,000 payment from the winning bidder actually wasn't a bidder because it was a no bid contract, but the party that got the contract then gave the mayor $13,000 after the contract was let. That he was prosecuted under federal corruption law, and the Supreme Court said we don't see nothing to see here. And they said that if the money wasn't given as a bribe because it wasn't paid before the contract was let, it was paid afterwards. And the Supreme Court on the last four federal corruption cases has extremely limited and narrowed the federal corruption law, and there's several cases now going through the system. Senator Menendez in New Jersey, he'll have his case before the Supreme Court, and others as well. Eric Adams, a New York mayor, and we'll see what the Supreme Court does in terms of patrolling corruption, an area that they know a lot about and don't like to enforce, at least as to themselves.
Let me throw one more thought in here. This is a Supreme Court that I think has always upheld the First Amendment free speech rights. I think free exercise rights. It likes guns, and the reason why I mention this is and it's struck down Roe versus Wade. I think we're going to get to a point where it's near absolutes on all of these come into collision. Like, for example, the right to distribute information about reproductive rights and abortion is going to come into, which is a First Amendment issue, is going to come into conflict with something like the Comstock Act. I'll be curious to see how it plays out. But at this point, it's 1:30. I want to turn it back to our host, Sarah. Do you have any closing things that you want to say to the audience?
I don't have anything else, and I don't see any other questions here in the chat. So I am going to go ahead and stop the recording.